Montesquieu said that each legal system presents a different vision of justice. And now this means that each country or each part of a country has a different legal culture. And this means, again, that meaningful comparative law and comparison of legal systems never consists of merely comparing them outside of their context. So if we ask ourselves, what is culture? Now, culture, of course, is a term with many different meanings, but I would like to use it in the sense that Gert Hofstede uses the term, and that is, he calls it all the learned patterns of thinking and acting. Or one can put it differently, the collective programming of the mind, which distinguishes the members of one group from another. Now, for present purposes, we're interested in not in culture generally, but in legal culture. And by legal culture, we mean the collective habits of thought and action of the legal opinion makers. And that is to say, the lawyers, the judges, and academics in a particular legal system, but also those in the legal system who use the legal system and who are subjected to the legal system. Now, a particular legal culture can be influenced by a variety of societal forces. Historical accident, political imperatives, including commitment to human rights, tolerance to difference in a particular country, attitudes toward corruption, etc. And culture, and the legal culture in turn, has a direct bearing on the substantive rules of law in a legal system. Now, I'd like to illustrate the importance of legal culture in doing comparative law by looking at one particular part of legal culture, namely the culture of giving reasons. Now, here we have on the one hand two very different systems, in the common law and in the civil law. And I'm going to use, first of all, the English law and, on the other hand, French law to explain this difference in the culture of giving reasons. Now, I think, as everyone in a common law system will know, that judges, modern judges, are not merely interpreters of the law, they make law. And this is, in effect, the doctrine of precedent. And it appears that the giving of reasons is a key thing in judicial lawmaking. And in fact, the practice of giving reasons is historically linked to the emergence of the doctrine of precedent itself. Since more or less the middle of the 19th century, judges have been in the habit of formulating their reasons in written judgments, despite the fact that at that stage they were not obliged to do so. Now, there are several explanations for the rise of reasoned judgments. And the first is that the giving of reasons legitimizes the exercise of public power by judges. In other words, judicial lawmaking is justified to the extent that it takes place in accordance with reason, or, in other words, is reasonable. But there are also more pragmatic reasons. In other words, that by the giving of reasons, judges protect themselves on appeal. And one can see here that the centralized appeal system that emerged in England around about 1875 was more or less the same time that the practice of the giving of reasons for judgments also emerged in England. Now, we also know that in such a judgment, only the ratio decidendi is in fact law. So the concept of the ratio decidendi, the essence of the judgment, places a formal limitation on the power vested in judges. Only a rule acted on by the court can rank as binding. And a judicially formulated rule does not bind except insofar as it justifies the outcome in the particular case in which it appears. Now, this is the approach in the English common law. On the other hand, there is the very different